We got a breaking story coming out. We got a brand new ruling in favor of Planned Parenthood, in favor of women's rights, in favor of reproductive rights, issued by Judge Talwani, a federal judge in Massachusetts. She's issued a preliminary injunction to stop the defunding of Planned Parenthood Federation and all of its affiliates who were ultimately targeted by Trump and MAGA when the budget bill was passed, effectively creating a defunding mechanism for anybody that looks and acts like Planned Parenthood, that provide abortion and birth control and family planning and receive over $800,000 a year of Medicare and Medicaid. That's primarily most, if not all, of Planned Parenthood. Now, there were two suits. There was one suit that was brought by Planned Parenthood in front of Judge Talwani, in which they argued that they were being targeted unfairly, unconstitutionally by Trump and MAGA. That case, Judge Talwani agreed with Planned Parenthood. It went up to the First Circuit Court of Appeals, where it currently sits, and the First Circuit has blocked Judge Talwani's order in favor of Planned Parenthood. Come to the rescue is like the cavalry, 22 Democratic states attorneys general, including California, Rob Bonta, New Jersey, Matt Platkin, and a whole group of other all blue state Democrats who filed their own suit, claiming in a different constitutional argument that the defunding mechanism, taking away money from Planned Parenthood because they provide abortions, also violates the spending clause of the Constitution, particularly its notice provision, because the states were not given proper notice in order to make plans. They administer their Medicaid programs, and therefore they did not have time to find other funding to replace the loss of Medicare funding, Medicaid funding, if you will, to Planned Parenthood. That has been successful. Another preliminary injunction just issued by Judge Talwani. She's, and I'm going to cover it all for you right here on Legal AF. Sure, I'm traveling, but these issues are very important, and there's no time to wait or to waste. You're on Legal AF. Take a moment, show your support, hit the free subscribe button. Okay, Judge Talwani, an Obama appointee up in Massachusetts in the district court. You might remember that she also issued a couple of stinging rebukes of the Trump administration when they tried to cut off food stamps and food supplement payments, known as SNAP, during the shutdown. Same judge. She had two cases in front of her. One of them, as I said, brought by Planned Parenthood directly. They argued that they were impermissibly targeted because if you read the way the new provision of Medicaid worked, it was effectively only aimed at Planned Parenthood. It was like, well, if you happen to be an organization that provides family planning and reproductive counseling and maybe abortion, and you get more than $800,000 a year of Medicaid, you're going to be defunded. Okay, that was like 99% of Planned Parenthood and its affiliates. That case is up, still on appeal at the First Circuit Court of Appeals, which sits in Boston. And they blocked Judge Talwani's decision on that until they can issue their they can get around to issuing their final order on appeal. So the 22 states, and I've had the pleasure of interviewing most of the Democratic attorneys general out there, including the ones leading the charge here, Matt Platkin from New Jersey and Keith Ellison, Rob Bonta from California. They came to the rescue of Planned Parenthood. They said, you know what? We've got our own injury that we can sue on as a plaintiff. We've got our own problems. We have our own standing to redress our injury through filing a suit. That's how it works. You have to have standing showing your own injury in order to bring a suit. They said, we have our own because we administer the Medicaid program. And they dropped this on us, a month or so ago without warning. In September, and said, basically, you deal with it. We're cutting off all funding for reproductive rights and for planned family planning without notice and cutting off the funding related to it. That is a violation, they argue, differently than Planned Parenthood, as only states can do, of the spending provision of the Constitution, which is how Congress solely is empowered under the Constitution to have the purse strings, to send out the money. They already allocated this money. They already allocated it to Medicaid. Medicaid's state plans have already been adopted and implemented, and you can't change the rules of the game at the last minute, especially without notice. It's that arbitrary and capricious aspect and constitutional violation and due process violation that is being argued by the 22 states. Let's take a time out for a minute. Where are the blue states? Where are the red states in this? They just sit back and rely on the blue states. Now, the blue states only got an injunction that helped 22 blue states. That's it. Because the Supreme Court, United States Supreme Court, has questioned whether district court judges should be able to issue broader injunctions or not. Nationwide injunctions are frowned upon. So the blue states run in and say, give it to us for the 22 and leave out the other 28 states or so. But that harms the red states. The blue state attorneys general don't want to do it that way, but that's the cards they've been dealt. But think about the people in the red states, in Alabama, in Mississippi, in Louisiana, in Tennessee, throughout the country, in Wyoming, where women just had their reproductive rights further compromised and undermined. It's bad enough MAGA ripped out of the Constitution a woman's right to choose 3 years ago in the Dobbs decision, but now medicated abortions are under attack and just reproductive counseling through Planned Parenthood. This is, as we keep saying over and over again, this is Handmaid's Tale in real life. It's as if it was a documentary. So Judge Talwani issued her preliminary injunction. She's keeping it in place for 7 days. In other words, she's not going to enforce it, I guess is the better way to put it, for 7 days, to give both sides time to run into the First Circuit and get guidance from them. And if there's no block of her order, it will go into effect in 7 days. I assume there will be an immediate emergency appeal by the Trump administration and Health and Human Services up to the First Circuit. They'll try to argue it's effectively the same issue as before, although it's not. The states have a very unique cause of action and constitutional analysis that only they can bring. And I'm very, very proud of what they've done here. I'm going to have Rob Bonta, the California Attorney General, on in the next 24 hours to talk to us about this case as well. So I'm glad you're here. Hit the free subscribe button. As you can see, I'm on holiday, but there's no rest. There's no rest at this period for anyone. We've got to be together here on Legal AF. Take a moment, hit the free subscribe button. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.